Good morning, Om Swastiastu, Namo Buddhaya, Shalom, Salam Kebajikan, Assalamualaikum warahmatullahi wabarakatuh. It is a great pleasure for me to open the second round of public discussion on human rights mechanism for the fulfillment on human rights today. As you may aware that this public discussion is part of the program called as joint course or class on human rights master degree held by Fisipol UGM, Mahidol University, and also in collaboration with the postgraduate program of Magister Legal Science of Faculty of Law UGM. So today's session, we have three distinguished speakers which have a great experiences on the topic of the effectiveness on human rights mechanism in Indonesia. As you may aware, Indonesia has very unique and complete domestic mechanism on human rights. We do three national human rights institutions, that is National Commission on Human Rights or Komnas HAM, National Commission on Violence Against Women or Komnas Perempuan, and National Commission on the Protection of Child, KPAI. So this institution has certain roles in promoting and monitoring in human rights. So we do have also ombudsman, but today we don't invite ombudsman yet, which is some aspect has worked to the effectiveness of government services related to human rights issues as well. So today public seminar, we want to know more about the institution's work and its effectiveness and their struggle in running their mandates. So I will hand the sessions to my colleague, Pak Gafar, to chair this session. Pak Abdul Ghaffar Karim is a senior lecturer for the Faculty of Social Political in UGM. Time is yours, Pak Ghaffar.
Terima kasih. Thank you, Bayi. Good morning, everyone. First, I would like to thank all these prominent persons, the commissioners of many key institutions in Indonesia regarding the human rights, for being with us today. And thank you for the students for being here. Pak Beka, Bu Andi, dan Bu Rita. These students come from many countries. They are part of the joint program on International Master on Human Rights. And it's jointly managed by Mahidol University in Thailand and Gadjah Mada University in Indonesia. And for this course, we managed as a cross-faculty program because we jointly manage this with the LLM program at the Faculty of Law managed by Bayi and as the part of MHRD program at Fisipol UGM. So it's really cross-country, cross-discipline program. And first, I would like to introduce the speakers here. We have Pak Beka Ulung Hapsara, the Commissioners of Indonesia's Human Rights Commission. Pak Beka has been a leading activist in Indonesia before he joined the commissions. And also we have Ibu Andi Yetriani. He's the Commissioner of apa bahasa Inggrisnya itu ya?
On Violence Against Women.
National Commissions on Violence Against Women, gitu ya. Komnas Perempuan, Komnas Nasional Anti Kekerasan Terhadap Perempuan. But otherwise, people publicly know the institution as Komnas Perempuan, the Women Commission, the Women National Commission, but it's focused on the issue of anti-violence. So we have Ibu Andi Yetriani, who also has long experience in the topics. And we have Mbak Rita Pranawati, the Commissioner of KPAI, Komisi Perlindungan Anak Indonesia, the commissions of the Indonesian Commission for Children Protections. Pak Beka has been with us, ya, sudah berapa kali di kelas ini ya Mas Beka ya?
Ini untuk yang kedua.
Kedua kali. He also teach this class last year, but this is the first time we manage this as a more public session that will be published later after the class. So Pak Beka, Bu Andi, and Burita, we have students from all over the world, basically. We have Adnan from Bangladesh, we have Sharmila from Nepal, we have Ice and Patch from Thailand, we have some others from Indonesia, including an Indonesian who are currently staying in Bangkok. So this is a cross time zone session, and I believe it's still 8 a.m. in Bangladesh. So we will manage this session first with the presentation from our guest speakers, starting from Pak Beka, followed by Bu Andi, and then concluded by Burita. We would like to ask the speakers to share their experience and managing the institutions, including the challenges, the problems, the issues they face in playing their role in the institutions. Probably we will give them about 15 minutes for the presentation, and then we will then follow with the questions and comments from the students. We will start with Pak Beka and then followed by Bu Andi and then Burita. Pak Beka, will you start now?
Yes.
Silakan, 15 minutes.
15 minutes. I'll try to exactly 15 minutes.
It doesn't have to be exactly.
It's very hard.
More or less 15 minutes.
More or less than 15 minutes. Yes. Thank you, Pak Gafar, Mbak Ayi. Very good morning, everybody. My name is Beka. I am from National Commission on Human Rights. Then I will presenting, because I already prepared the material for this very noble forum. So I'll try my best to presenting in more than less than 15 minutes. But yeah, I know it's very hard. Let me start from beginning. Yes. Yes, this is my second become a guest lecturer, because last year actually offline before COVID-19 attacking all over the world. So I hope this presentation also is clear, and then we can discuss it more further about this theme or our experience during this very hard situation and condition. So this is Komnas HAM actually, because this year we already 28 years since the first established by presidential decree on 1993, and then after that Komnas HAM was reinforced by law number 39 on 1999, which is determine the existence, objective, function, members, principles, assignment, and authorities of Komnas HAM. So actually, if we compare with other state auxiliary bodies like KPAI or Komnas Perempuan, we are the oldest. And also comparing with the Ombudsman, Judicial Commission, and other state auxiliary bodies. So we are oldest, but right now, actually, the position of the National Commission on Human Rights is still to be strengthened, because some challenges we cannot facing without our recent mandate or authorities. So like other institution, we are independent institution. So we have a similar level with other state institution. And then the function, actually, we are right now working based on 4 law, or 4 big mandate. The first one is mandate based on law number 39, which is the function to conduct study and research, conduct dissemination, monitoring, mediation. And then based on law number 26 on 2000s, we have a mandate to investigate the gross human rights violation. Only to investigate the gross human rights violation. And then according to law number 40, 2008, about the elimination of discrimination based on race and ethnics, we are conduct the supervision of the central and regional government policy regarding race and ethnic discrimination regularly, also or by case. So we have a mandate, investigate, monitoring, and then also supervision, like a government policy that sometimes discriminate based on race and ethnic. So this is actually this is the definition of human rights. We can skip it because we only have 15 minutes, so we can discuss it more detail on this definition.
Don't worry too much about the 15 minutes. 20, 25 is
still
okay.
in my head, actually still in. So actually, this is the human rights instrument that we already ratified. If we compare with other country in ASEAN, maybe in ASEAN, we are the highest commitment on ratifying the human rights instrument, because we already ratified 8 instrument and then 2 optional protocol. Yes, this is later on maybe. So this is actually some of basic principle of human rights, the state obligation towards human rights. So based on law number 39, we have 5 obligations by state actually. Obligation to respect, to promote, to fulfill, to protect, and to enforce. The detail is like this. So the obligation to respect, the state's obligation retains itself not to interfere except by legal means. For example, the right of life convenes the state obligation not to commit murder. So we have a debate on the effectiveness of death penalties, and then also how about the state reinforce the death penalty as a final stage of the human rights obligation, for instance. And then also the rights of personal integrity, physically and mentally, convenes the state obligation not to torture. Right now, maybe Mbak Rita and then Andi can add more this. Actually, right now, Komnas HAM, Komnas Perempuan, KPAI, and then Ombudsman, and one is witness protection institution. We have a joint action on national preventive mechanism on how to avoid the torture in our country. And then this is the promotion of human rights. So the state obligation to create conducive situation for promoting and human rights enforcement. For instance, in our police institution, actually, they already have like a chief of Indonesian National Police regulation regarding the implementation of human rights principle and standards in the discharge of duties of the Indonesian National Police. So, that's one example. The second example is the initiation of human rights cities. Komnas HAM for the last 7 years already promoting human rights cities as a strategy to promote human rights to the 540 cities and municipalities in Indonesia. And then the other obligation, for instance, is fulfillment of human rights. I think we already know about this definition. So the obligation to undertake the legislative, administrative, judicative, and practical steps that necessary to ensure the human rights implementation as widely as possible. The protection of human rights. So this is a state obligation to protect all people, Indonesian citizens, foreigners, and statelessness people, not only the offense committed by state, but also the violation action committed by entity or other parties or non-state. For example, a Cikesik case. Cikesik case is the case that Ahmadiyya peoples attacked by the vigilantes, the intolerance group, and then after that, the attacker, the vigilantes group, only punished 3 or 6 months, even though there's 3 people killed, and then the house is burned, and then the other infrastructure is also, the other properties also attacked and then destructive. And then also Syiah case in Sampang, and maybe this is Pak Gafar Karim's authorities to explain this case in Syiah, and then also GKI Yasmin, this church then already has highest decision by law, but until now there is no implementation in the field, because the mayor of Bogor right now still considering so many aspects, then they cannot decide whether the church should be built or not, because there's so many considerations. And then the enforcement of human rights, I think is more likely on how to enforce the gross human rights violation, because right now there's only it's already 12 files. I will explain it later on, that has been discussed between Komnas HAM and then the General Attorney, but still cannot be continued, because maybe more because of political will of the government that is still very lack. This is a human rights violation, so I will try now. This is the data that showing the complaints reported to Komnas HAM from 2015 until 2019. So the highest complaints happened in 2015. We received 8,249 complaints that comes to Komnas HAM. And then the last is in 2017, it's about 5,000 complaints, 387, and then also in 2019, we only received 5,314 complaints. So this is a figure that showing about the complaints that comes to Komnas HAM. And then what is a complaint about that come to Komnas HAM? So it is the list that already structuring by staff based on law number 39, 1990. So even though we receive more than 5,000, but not all complaints become our mandate to proceed. And then sometimes we send it back to the complainer or send to the other institution that has mandate to continue or to proceed those complaints. But this is the figure that the classification of rights complaint in 2019. So the most complaint is about the right to welfare or hak atas kesejahteraan. So this we have. So the figure is constant like this. The most complaint is about the right to welfare, and then continue by the right to justice, and so on and so forth. This is the primary complaint based on the classified complaint parties. So the the top level or the highest institution that been complained is police. And then continued by corporate, and then the local government. Police about unprocedural on law process, slower process in case handling, criminalization, violence and torture. And then if we discuss about corporate, we have land dispute, employment dispute regarding normative rights, environmental pollution due to cooperation, and so on and so forth. And the local governments also complain about local owned assets, dispute regarding land, and then employment dispute, and freedom of religions and beliefs. This is also become a concentration of complaints by people that comes to Komnas HAM. So this is a primary complaint based on the rights mostly received, the rights to welfare, land dispute, labor dispute, employment dispute, the right to safety is about threat or violence to soul and thing, arbitrary detention, intimidation and terror, the right to justice about unprocedural law and process, unprocedural law process, slower process in case handling, criminalization, and violence. And this is one of our priorities issue during our period. One is the agrarian reform. The typology and the spreading of agrarian case, if we discuss in 2019, is very much like this. So we have forestry, infrastructure, and spreading all across Indonesia, not only in Java, but also cross from Aceh to Papua, which the typology is very much like this. And then the other priority is priority issue for Komnas HAM is intolerance or violent extremism. So the distribution of intolerance extremism case, if we take a look for the based on the region, the Central Java or Jawa Tengah is the highest complaint about the intolerance case in 2019. I actually is very surprised because public knows that the most intolerant regions is West Java, but based on the complaint that received in Komnas HAM, actually Jawa Tengah, because there's so many complaint comes to Komnas HAM about like permit for the church, and then also sometimes intolerance group comes to minority groups and then distract their ceremony or something like that. The subject of intolerance extremist cases, mostly complaint institution, is central government, and then the local government, education institution. Right now, I am still campaigns on the SKB 3 Menteri. What is SKB 3 Menteri, Pak Gafar? It's like a joint
decree of
the three ministry about the school uniform, because maybe 1 month ago there's a case in Sumatera Barat, and then organisasi masyarakat or people organization, and then also the people itself that been complained. So this is the gross human rights violation. So we have actually we adopt two kind of the gross human rights violation. The first is genocide, and then the second is crimes against humanity. Because if we take a look at the Rome Statute, there's four kind of gross human rights violation, but based on law number 26 on 2000, we only adopt two kind of gross human rights violation, that which is genocide and crimes against humanity. So this is the file that's investigated by Komnas HAM and already finished. Right now, all the files is in General Attorney's hand because they have an authority to proceed our report. So we have 65 Mysterious Killing, Talang Sari, Trisakti Semanggi 1, Semanggi 2, then May 98, enforced disappearance, some case in Papua, and then some case in Aceh. So this is that I already mentioned about the judicial mechanism in Indonesia. The Komnas HAM as an investigator, the General Attorney as the investigator itself, which is penyidikan. And then non-judicial mechanism, actually after the law of commission and reconciliation truth has been revoked by Constitutional Court, there was no longer any non-judicial mechanism. So the only mechanism to solve, to finish the gross human rights violation is by judicial right now. And then I think this is the recommendation of Komnas HAM about how to solve the gross human rights violation. So we already met President Jokowi 3 times or 4 times during our period. So this is maybe the most frequent period that Komnas HAM met with the President. So in December 11, we sent a letter, we sent a recommendation to solve the gross human rights violation. One is the President immediately make sure the Attorney General use his authority to investigate it 10 at a time. But right now it's 12 cases that files that Komnas HAM has completed. And the second, the President could use, this is the interesting one, the important one, the President could use Article 47 of Law number 26 of 2000 concerning the settlement throughout the Commission of Truth and Reconciliation that was established by its law. So even though the law number 27 of 2004 concerning reconciliation truth has been revoked, but President could use can use Article 47 on those law by number 26 to the settlement of reconciliation commission. So I think I will finish it, stop it here, because maybe we can discuss it about the human rights situation in 2020 in discussion, question and answer. Thank you, Pak Gafar.
Thank you, Pak Beka. I think we have growing issues on some cases of human rights, despite the hope that the human rights issue will decline after the political reform, but that's not what happened. So thank you once again, Pak Beka. So next we will have, who will be first? Bu Andi first.
Thank you, Pak.
Bu Andi. So everyone, we will have Bu Andi next. Bu Andi is the chairperson of Komnas Perempuan, the chairperson of the Commission for Women, National Commission for Anti-Violence Against Women. Bu Andi, silakan juga sama seperti Mas Beka, officially 15 menit, tapi ya santai lah. Time is yours, Bu Andi.
Thank you. Good morning, everyone. In Indonesia, I really would like to address selamat pagi dan salam Nusantara serta salam sehat untuk kita semua. Just wish that everybody is in a healthy condition, and also a greeting, warm greeting from the archipelago of Indonesia. It's a great pleasure for me to be able to speak before you all. And here I would like to make a special address to my actually seniors, and I can actually say teachers, my guru. Ada Mbak I, yang we know that she's also leading the LLM in UGM, and also there is another, used to be a colleague of mine at the commissioner, Pak Agustinus Suprianto, who was the commissioner in my first batch of, in my first term as commissioner back in 2010 and 2014. So this is my second. Selamat pagi.
Selamat pagi.
Mas Agus.
Yeah.
This is my second term as commissioner, and I was asked by the other 14 commissioners to be the chairperson. Komnas Perempuan, similar to Komnas HAM, is governed with a collective collegial perspective. Hence, a chair basically is not the utmost person at decision making process, but the utmost decision making body is actually the plenary meetings of the commissioners, of the 15 commissioners. So let me share my PowerPoint, and I hope that I can actually introduce Komnas Perempuan in 15 minutes. Sorry. So this commission was actually established back in 1998. As mentioned by Commissioner Becca, by then, Komnas HAM is already established. But during the tragedy, there is a need for a special body that is comprised of people with a specific expertise in looking at violence against women. Since the tragedy back in 1998 involved rape, gang rape in particular, as well as other sexual violence committed against particularly ethnic Chinese women, and the exposure of this incident has actually encouraged other women from various areas of Indonesia experiencing violence in the name of special military zone policy. So Komnas Perempuan can claim that it is actually the first institution established in the Reformation era of Indonesia, because in May 21st, the stepping down of President Suharto, who has affirmed authority for the last 32 years of new order regime in Indonesia, stepped down. And it actually marked the new phase of political era in Indonesia, known as the Reformation. It was Komnas Perempuan was established with a presidential decree not long after the ratification of the Convention of Anti-Torture. Hence, at its statute, it was stated that Komnas Perempuan need to build its framework with not only Constitution and the Convention on the elimination of all forms of violence against women, but also in the spirit to enact the Convention of Anti-Torture and other inhuman, degrading punishment or treatments. Komnas Perempuan is actually the one and only institution in Indonesia that has a specific mandate to utilize the Anti-Torture Convention. We are also asked to use other relevant national frameworks as well as in international human rights instruments. Similar to Komnas HAM, we have the, I hope I put it here, okay. We have the authority to conduct public awareness and education, research and review of relevant laws and regulation, monitoring fact findings and reporting on violence against women and women's human rights. The only difference that we have with Komnas HAM, since Komnas HAM is established with law, legislative law, we do not have what's called subpoena power. So we do not have the authority to request for all parties to provide us with evidence that needed in order for the fact-finding and monitoring. However, since the expertise of Komnas Perempuan is very particular, Komnas Perempuan, with the request and also discussion, we do also support some of the Komnas HAM's fact-finding missions. And we are still, as Becca mentioned earlier, in a cooperation of particular issues on incidents of human rights violations that affected a community in which women needs to have a specific attention. We are also authorized to provide input and recommendation to the executive, legislative, and judicial branches at the government at both local and national levels, as well as independently developed our cooperation at regional and international levels. So that structure, in our presidential decree, we were allowed to have 19 commissioners. However, in the last 3 terms, we only have 15 commissioners with various backgrounds and expertise in order to meet the Paris Principle for NCSRS. The document of Paris Principle can be distributed later. In 2020-2024, we have 12 women of 3 men, and also 2 of the commissioners are people with disabilities. It is according to our statute that each commissioner can serve for 2 terms, both consecutively or in separate terms. I myself, as I mentioned earlier, is now on my 2nd term and will be the last term that I can serve at Komnas Perempuan, although I have started work with Komnas Perempuan since 2000. We have an executive body led by a Secretary General. And according to our presidential decree, we are only allowed to have 45 staffs, which actually hindered Komnas Perempuan from works effectively. But with the support of other grants, we are now working with 80 staffs. In our terms of 2020 and 2024, we have 5 priority issues, namely women in conflict and disaster situation. This is actually formulated very early January, and we didn't realize that by then we are heading to pandemic COVID-19, which has a prolonged impact on our life up to date. The second priority issues is women detainees, prisoners, and in detention alike condition, women workers or women at working space, sexual violence in all contexts, and also on ensuring the strengthening of institutional capacity. I just want to highlight some of the key achievements of Komnas Perempuan in the last 22 years. So I would like to categorize it into 4 items. Namely, one is the knowledge building. Since we have the authority and also mandate to conduct research, fact findings, and monitoring, that is actually the foundation for all Komnas Perempuan's advocacy. Hence, it is the knowledge that needs to be generated based on the experience of women victims of violence, as well as the women defenders. And through that experiences and knowledge, we built our policy recommendations through several laws that managed to be issued, as well as those that are now being discussed, including the anti-sexual violence bill, which is still on delay. We also use this knowledge building to develop strategic networkings. So the strategic networkings is not only to do the policy advocacy works, but it starts from the very beginning of generating the knowledge needed to transform the situation. And it is also that with that knowledge, we build our campaign or education materials in order to gather more public supports. Besides that, we are also initiating a philanthropic movement to support women victims of violence through the services provided by societal-based efforts. We call this philanthropic movement Pundi Perempuan, and it is managed by another foundation, since Komnas Perempuan is a state institution and we are not allowed to handle a separate public budget outside our own institutional budget. So now that's some brief introduction of Komnas Perempuan. What are the challenges and opportunities after 2 decades of reformation in eliminating violence against women? Let me just put you to a very brief context of women's vulnerability to violence. So we are looking at conflict and disasters. Becca just touched the issues of agrarian cases. And it also linked very closely to the natural resources conflict and land disputes. And we are looking at some of the prolonged conflicts, such as in Papua, as well as in Aceh, despite the fact that it has actually signed a peace accord back in 2005. Also on religious intolerance and women in the context of violent extremism. Komnas Perempuan is also concerned the fact that Indonesia is very prone to natural disaster, and this may actually resulted in a vast number of women located in the IDPs camps or the internal displaced person camps. And we have actually conducted a series of research on the impact of pandemic COVID-19 to domestic violence, sexual violence, as well as exploitation and impoverishment of women. We are concerned that the fact that the child marriage is still rampant with women leadership is very fragile, despite the fact that the members of MP, the women members of parliament is increasing in as the result of the 2019 election. On women at work, we look at the income gap and also other cases of violence for sure, including the maternity facilities provided, and also on the issue of migration. What I would like to highlight that not only the poverty actually create a vulnerability specific to women, but the violence itself has created a more severe condition of impoverishment. And this is actually confirmed by the study of Ministry of Development, National Development of Indonesia, where the number of women living in poverty is higher at almost all levels of age and almost all region. And the long life expectancy of women means actually a longer period of poverty. Now, we are looking also on the cases of violence against women reported to Komnas Perempuan. There is an increase of number reported. On one side, it means that the victims is actually more alert that their cases can be reported. And it can also mean that the confidence of society on the legal process is increasing. However, it is a very important to look at the capacity to handle those cases. Just before I mention about the capacity to handle cases of violence against women, I would like to highlight that from all the cases, domestic violence is still the majority of the cases reported to Komnas Perempuan, with an increased number of sexual violence committed by those not only at home, but also at education institutions. There are also cases of religious minorities, attacks against religious minorities and natural resources-based conflict, as I earlier discussed. But we are also concerned that the fact that there are many more cases of criminalization of women human rights defenders in all cases that they're advocating. After 22 years of reformation, there are some achievement on regards of policies. We call it the conducive policies, but also the number of discriminatory policies is at highs. It's increasing. So what we are looking at is actually the weak measures to correct the discriminatory bylaws, and how some of the conducive laws has been utilized to criminalize women. For instance, on anti-domestic violence law, some women who actually left house for leaving their house for safety are then being sued by their partners for neglecting the family, which is criminalized under the domestic violence law. Now, there is also, as I mentioned, prolonged delay on anti-sexual violence bill, which is needed desperately by women victims of violence. We are looking at some of the opportunities, including National Priority Program on policy harmonization. And also there is a very interesting shift of political responses to intolerance in the last 5 months, I guess. And I would say that it is also encouraged by the persistent movement of human rights and tolerance for the 2 decades in Indonesia. Now, I touched the issue of the capacity to handle cases of violence against women. On paper, there is an increased number of institutions providing services for women victims of violence. That is the number on the right hand. But if we are looking closer to that condition, we would actually find that most of these services is only available in Java Island and also in urban settings. And it has actually chronic situation that has not been addressed well enough, such as the lack of human resources, lack of budget, and also in the lack of safe house, etc. Now, with the new policy on the position of Ministry of Women Empowerment supported by Ministry of Home Affairs, we are expecting that some of these chronic problems can be addressed better. I would not go through in details. You may later discuss this, but what I'm trying to highlight is the fact that the capacity of servicing or handling cases of violence against women is limited. The situation of COVID-19 pandemics exposes and aggravates the existing problems already there. And it obstructs or it's actually undermined many of the cases, since the services need to look at their capacity, at the aspect of infrastructure, policy barriers, and also their own support, because the defenders is also put themselves at risk of health, safety, and income. Now, this is my last page of presentation. I would also like to highlight other challenges and opportunities in advocating women's human rights issues. As mentioned earlier, Komnas Perempuan is established in the midst of conflicts in Indonesia. Not long after the May 1998 tragedy, conflict erupted in almost all areas in Indonesia. And we have not seen a firm political will to resolve past violation of human rights, which namely those conducted in the prior to the Reformation, as well as the conflict occurred during the Reformation time. There is ongoing denial, particularly on sexual violence committed within the past violation of human rights incidents. and it is prolonged the impact and actually created a condition where possibility of reoccurrence is very apparent, namely the discrimination and racism against two in particular, the Chinese community as well as the Papuan. We are looking at policies of ambitious development plans, of infrastructure, of exploiting or extracting natural resources that undermining the due diligence principle to ensure protection of human rights, and they will create conflict in various areas. Corruption and weak law enforcement, political system that encourage primordial identity politics and money politics. But let me just touch to the culture of denial and blaming the victim, and as well as repudiation of feminism. So we are actually looking at the backlash of the feminist movement enacted by the more conservative groups, claiming that the progress women has achieved up to date is actually risking the democracy and risking the unity of family. And this is actually neglecting and even disproportionately the undermining the contribution of women's movement in the advancement of the state and the society. We are grateful that despite all of those challenges, we have a very prominent women and youth movement in human rights. I think the development of internet communication and technology in communication also allowed us to have a more active campaign and advocacy, particularly during the pandemic time. We have also local initiatives as well as national initiatives. Some is actually a formal one, such as Truth and Reconciliation Committee in Aceh, as well as international solidarity. On the last note, at organizational level, we are still facing the fact that knowledge on national human rights institution is very limited, not only in Indonesia, but I may actually say that in various parts of the world. Even more so on national human rights institution with a specific institution, with a specific focus such as Komnas Perempuan. And in Komnas Perempuan case, we have a very strong institutional barrier to our institutional capacity due to the number of staff allowed in our presidential decree and also in budget. We are facing a budget cut due to the pandemic and rapid turnover, since we are not able to provide adequate salary for our staffs. However, we are looking at more supports from other national human rights institutions, including Komnas HAM. Thank you, because up to date, our secretariat on budget issues are still with Komnas HAM, and also from the ministries and other social movement. And we are having an ongoing discussion on the revision of Komnas Perempuan Presidential Decree, and also grants from our international partners. I hope I am not overwhelm you with information, but I can send this, and then later on you can ask questions, and I would like to also be part of the discussion. Thank you.
Thank you, Bandi. Maybe we should also highlight that the Komnas Perempuan and Komnas HAM also reside in the same area, in the same building compound.
A parking lot. That's what we said.
The institution share the parking lot. So yeah, that's a very interesting story of it. So thank you once again, Wandi. Now, from general human rights issue to women issue, we are going directly to the children issue with its own challenge. Because as for the children, one of the problem is the political cohesiveness of children, because they don't unite. There is no such thing as a children association of the world, for example. But there are some women movement, but even children issues are taken care by adult issue. There is no movement for children. So it will be very interesting looking at the children human rights perspective, and we are lucky to have Mbak Rita, Bu Rita Pranawati here. Bu Rita, time is yours. Also officially 15 minutes, but we will be flexible with that.
Okay, thank you Pak Gafar, Mbak Iyi, Mbak Andi, Mas Beka, and all of the students here. This is time for me. Selamat pagi, salam healthy. Hope you all in a healthy condition. And thank you very much for inviting me in this important session, because we can share with the Komnas HAM and Komnas Perempuan. And I will share my presentation. Yeah. Hope this is clear. Okay. As the introduction, KPI is an independent state institution established based on the 23 of 2000 on child protection law. And then there is two amended. Firstly, number 35 on 2014. And then currently with the law number 17, that is famous with the castration law. Yeah, but yeah, even not all the issue is about castration. And then Indonesia has ratified CRC in 1990, and then it's come to the presidential decision, then come to the child protection law. We have child protection law in 2002, and then the KPI established firstly in 2004. And today is the fifth period of the Indonesian Commission on Child Protection. We have 9 commissioners appointed by political decision, because it's come to the House of Representatives. And our mandate is mentioned in the verse of 76 of the Indonesian Child Protection Law. Firstly is to monitoring and evaluating of the child protection law, not only child protection, but also the fulfillment of the child right. And then we develop inside of the child protection policy, collecting data and information. We also receiving cases and reported from the society, mediation for the violation against children, and research and analysis, cooperation with some NGOs who works with children, and reported cases to the authorities. The main mandate is to increase the effectiveness of monitoring on the protection and the fulfillment of children's rights. This is the biggest mandate. And KPI is mandatory in the national level, but in the provincial level, we have KPAD, Komisi Perlindungan Anak Daerah, but this is not mandatory, so we only have 5 in provincial and 40 in the district. The child definition in Indonesia almost the same with the others, but I only want to emphasize that children under 18 not differentiate whether they are married or not married. This is important because sometimes law enforcement officer still punish children with the general law, even because they got married. But actually in our law, even though as far as the children under 18, then we use the juvenile justice system law. And the legal standing of child protection, firstly is in the Indonesian constitutional. Each children has the right to live, grow up, and develop, as well as the right protection from violence or discrimination. And then I mentioned before, child protection law. And then we also have juvenile justice system law in 2012 that also mandated KPAI to monitor and evaluation the juvenile justice system law. And how KPAI work, there is also presidential regulation number 61 concerning KPAI. Here regulate about the status of KPAI and the supporting system. When Komnas Perempuan, the administrative support from become merged with the Komnas HAM, but KPAI is under the Ministry of Women Empowerment and Child Protection. Yeah, I will mention this is the child right principle, but as well as the challenge of the child protection situation in Indonesia. Firstly, is non-discrimination. Mas Beka already mentioned about the freedom of religion to wear or to not to wear jilbab. This is should be fulfilled for every child. But still KPAI receive some cases related to the discrimination, as well as the status of the economic sometimes, for example, for the health services. This is still problematic, as well as the perspective of society that girl and boy are different. They prioritize a boy, for example. This is still becoming a problem, including when we need to deliver the sex education, for example. People tend to give to the female rather to the girls rather than to the boy. Actually, they all need this kind of information. The second child right principle is the best interest of the for the children of the child. This is also because children under parents or under adult, then sometimes the best interest for them, not for the children. This in every situation, even in the public policy or even sometimes in the family. This is because children only have a political vote in 17, so this is not important for politicians or for the leaders to hire or to listen to the children's voice. And right to life and growth, this is important. Physical, not only physical but also psychological, because life is not only physical but also psychological. This term also there's a challenge from the society, because they only want to ensure the basic needs, especially for the physical one, but for the psychological one is not really taking care of them. And children participation here means children voice. Actually, the cases or something that is decided related to children, we need to listen to the children voice, including actually there is forum anak child forum. Then they also can participate in the we call it Musrembangda, the conference for decide the local development. Then forum anak or child voice can participate in this meeting. This is in the provincial level, national level, and also a district. This is the case handled by KPAI from 2011. I'm so sorry, not translated yet this page, up to 2020. Previously, the bigger cases is children in front of the law. But then during the pandemic, the biggest cases is from the family and parenting, mostly because of the situation, a conflict situation of the parents. Then it's come to the conflictual situation for the children. The second is the problem of fulfillment of educational rights during the pandemic, COVID-19, because the access to the gawai, gadget, and also the internet, sometimes they cannot catch up with those tools, and sometimes because of the economical situation, some children are being cut off by school because they cannot pay the school fee, for example. And the third problem is again in children as a victim of the physical, sexual, and psychological violence against children. And during the pandemic, the number is increased, up to 2 times from the 2019. And the child protection under the cyber situation also becoming conflictual because currently the children become victim of the violence in cyber. Is not only we didn't need against to meet to commit violence in sexual violence against children, but through the cyber, our children also are becoming a victim. And what are the priorities of the program in KPAI? And this is also based on the national development program by President and Bapenas, National Ministry for Development. Firstly is about the child right in the family, and this situation is mandated in CRC verse 5 that every family need to fulfill children right, and the state need to empower and ensure and develop the capacity of family, but we still lack on this situation. And fulfillment of educational right, because during pandemic, this is becoming a big problem. The violence against children in private, I mean in family, in public, including school or boarding with religious-based school. I mean, because there are some problems also in this kind of school. Violence against children in cyber, and then child marriage, Mbak Andi already mentioned, but fortunately we already we have new regulation that the age of marriage is 19 for both boy and girls. And we also have still problem on stunting and health basic services, trafficking and sexual exploitation, and it's a bit increased during the pandemic. And child labor as a scavenger and being prostitute during the pandemic increase. We have monitoring and evaluation in 39 cities, and this is very sad because the situation of pandemic truly affected to all of our children. And this is the specific institution responsible for the implementation of child protection: state, government, local government, community, family, parent, and guardian. The problem is here, the local government, because I already mentioned about the community, the parents, but I want to emphasize in the local government. For the KPI first, with the system building approach, this is norm and regulation, program and budget, and human resources. The structure of KPI itself independent, but the administration support is under the Ministry of Women Empowerment. This is not suitable with the Paris Principle, for example, with the minimum budget, with the minimum human resources, because they are only support by the low budget, and also a bit difficult to allow in to develop their capacity. While Indonesia is very huge, from Papua to Aceh, and with the minimum budget, so it's become difficult, and we only have 5 KPAD in provinces and 40 in district. This is the situation. While in the local challenges, law number 23 of 2004 about regional autonomy said that children is under the local autonomy, local government. That's the child protection implementation is really dependent on the provincial and district government. While maybe they have norm and regulation because of the child-friendly city, child-friendly city needs this kind of norm, but we saw that their program is very, very limited. Program and budget. The program, the heavy of the program is only in the how to respond the case, while the preventive, this is still limited. This is a big problem when we only focus on the rehabilitation process rather than the prevention. While the budget from our survey, 9 provinces only have the budget only 0.5 up to % from the whole of the provincial or district budget. This is very low. That's why it's a bit difficult. This is the challenge of the child protection implementation. And about the human resources, we know that some of the safe house or the child protection services, there are some cases that the officer commit the sexual abuse to the children who stay in the safe house. This is that's why it's a big problem in the child protection situation. And I will talk about the law enforcement. In the child protection perspective from the society, actually some cases are not reported because they feel that when they reported their case, it will be a long process, long journey, and they got the stigmatization from the society, which is not easy. And in the law enforcement officer, especially what we found is in the police process, the perspective of the child protection is not full because maybe they move from one department to another department. And also the newest cases is for example is in the east of the Nusa Tenggara, that the girl that kill someone because she will be a victim of rape was judged by the general, the KUHP, the general KUHP apa mas?
Criminal law?
Yeah, the criminal law. But actually it should be the juvenile justice system law. This is the example of the practice of the child perspective, child protection perspective in the law enforcement officer. And the facilities of the child protection, for example, for girls who are offender, still put in the adult, and some of the jail for kids, we call it LPKA, for children, still merged with the adult area. This is still the lack of the situation of law enforcement. And the process of juvenile delinquency is still need of improvement because we found that, for example, the decision of the court, for example, children cannot get it as far as KPAI can assist. That's when, but if not, but Indonesia is very big, that's another problem. Yeah, we ensure some this kind of rights for children, especially in conflict with the law. And the rehabilitation of the victim in Indonesia for children only reached 48.3%. This is also another problem. The problem, for example, because of the parents willing to stop the process of rehabilitation, the budget, and also the operational procedure from the government. This is the situation of the law enforcement. I guess that's what little insight, but may you can ask me some question. Again, that I want to emphasize that child protection is not only depend on the government, but it's come to the family, while the families, the perspective of the family is not all have the child right principle. That's becoming a huge problem in child protection. That's all, Mas Gafar. Hope you can understand what I'm saying. Thanks very much.
Thank you, Burita. I guess it makes everything more clear about how problematic is protecting children's right in Indonesia in a culture that is not really protective of the child. So everyone, we have discussed through general into more specific issues. We would like to later invite Bagi and Prof. Agustinus to give comment, but now I would like to invite the students to probably raise questions and issues to go to the discussion further. So Pak Agus already raised his hand. Or probably, Pak Agus, do you want to give comments, general comment first before we give the opportunity to the students?
It's right.
Ya, silakan, Prof.
Good morning, everybody. In the morning, I'm learning a lot and taking inspiration a lot from the latest developments from the 3 human rights institutions through the 3 speakers, Mbak Andi, Burita, and Pak Ulung. In this discussion, I don't think it has been discussed much about the issues of local religion, especially issue the followers of local religions. So I would like questions for the 3 speakers. First of all, I would like to ask Pak Ulung a short question about the protection of local religions that are widespread throughout Indonesia. The question is, what is the role and efforts of the National Human Rights Commission in protecting the followers of local religions? Secondly, I asked Mbak Andi a question. What is the latest development of protection for women, the followers of local religions, carried out by Komnas Perempuan? Thirdly, for Ibu Rita, what efforts has KPAI made to ensure the education of children of local religions, considering that schools in Indonesia usually only provide lessons on major or mainstreaming religions? One more question for Mr. Ulung. Considering the protection of local religions regarding both men, women, and children, is there any initiative from Komnas HAM to work together with Komnas Perempuan and KPAI to provide protection for them. I think it's all. Thank you.
Thank you, Prof. Perhaps we can invite comments from the our guest speakers first regarding the, for example, the local religion. I believe, for example, Mas Beka has been working closely with such issues. I also do. I'm currently doing the research on local religion at some places in Indonesia, Prof, and I've been in contact with Mas Beka intensively for this issue. But we will now invite the speakers for give quick comments before we are inviting questions from the students. Thank you, Prof.
Okay. Thank you, Prof. Agustinus. You can call me Beka rather than Ulung because it's not common calling the middle name.
Okay.
Yes, about your question. Actually, in terms of human rights, there's no differences between what we call it international religion or local religion, because there's no, we consider there's a equal position and then also equal definition between what we call it religion and local religion. About the role and effort about the local religion based on our experiences, actually we have right now formulated standard and norm on freedom of religions and belief. The standard norm and setting about freedom of religions and belief. Those kind of standard and norm and setting can be used by governments or activists or even academicians to advocating, to formulating the local policies, or to protecting the local religions, because there's so many details on those kind of standard norm and setting. That's the first one. The second one, and based on our mandate by law 39, we also conduct monitoring and investigation for certain cases on those local religion. For instance, like Mas Gafar said before, mentioned before, like Sunda Wiwitan. We join action with Komnas Perempuan actually to advocating them to protecting them their rights on in Kuningan area. So, and also we try to convince the Ministry of Home Affairs to issue a recommendation and protection to those kind of local religions communities. That for one example. The other example is also in East Nusa Tenggara. There's a local religion community called Marapu. Right now, they are facing investor from Jakarta that treat their land and also treat their tradition, worship tradition in East Nusa Tenggara. So that's one of two examples what we are effort to protecting local religion. But we also put those issues, local religion issues, in our umbrella issues called intolerance and freedom of religion. That's one of our priorities during our period 2017 until next year 2022, because we will be finished in 2022. That's my answer to your question. And then considering the protection for the local religion, is there any initiative joint action? Yes, we are. We, like I mentioned before, we have a joint action with National Commission Violence Against Women. Sunda Wiwitan and also the other local religions in East Nusa Tenggara Timur, East Nusa Tenggara, masyarakat adat Pubabu. There's also there's a joint action, and we have coordinating, and then sometimes share information what we are doing so far, and then come up with like a joint action in the field. So I hope this can answer your question. Thank you.
You're welcome.
Thank you, Mas Beka. Bu Andi or Bu Rita, do you want to give comments on the questions raised by Prof. Agus?
Yeah, maybe me. Some cases reported to KPAI regarding to the belief of the local belief. The problem is sometimes because they didn't want to the report cases to KPAI is because the children forced to choose one of the religion, the formal religion. That's why that's some reported to KPAI, and we do some advocacy. One case is in Central Java, for example. Then we coordinate with the Department of the Education in the local, the Central Java. Then the children can do their own faith, for example. This is their own belief, for example. This is what we do advocacy. And the other advocacy is with the Ministry of Religion and Home Affairs, because for example, the birth certificate will also related to the local belief sometime in the past. So currently it's become more easier with the new regulation from the Home Affairs. Maybe that's the KPAI doing, Pak Gafar.
Thank you. I'm sorry, can I add one point?
Yes, yes,
Mas Gafar.
Yes.
Yes, actually, the situation in Indonesia is very unique regarding to the local religions, because officially government claim that local religion is not religion, only belief. That's why the local religions is under supervision of Ministry of Education rather than Ministry of Religion Affairs. That sometimes make our advocacy or our monitoring is more difficult because sometimes if, for instance, in Sunda Wiwitan, in Kuningan, the PIC for those cases from the government side is come from Ministry of Education. But if we discuss with local communities, for instance, from NU, from Muhammadiyah or other religions, or for instance, from Catholics, we have to coordinate with the Ministry of Religion Affairs. That's make more difficult rather than to solve those kind of problems. So that's my additional comment. Thank you.
Thank you, Mas Beka. Mbak Andi?
Just to add to that, since it is governed differently, so previously the local beliefs, or in Komnas Perempuan we prefer to call it the indigenous beliefs, are actually facing various layers of discrimination. It is only after the issuance of Constitutional Court decision that they are allowed to be registered equally on public administration. However, it is also treated in a separate or in a different ways. So now in Indonesia, there are two forms of ID cards, one stating religion, the other one stating beliefs, in accordance to whom is actually registering their identity. And we have seen in Komnas Perempuan the increasing possibility of indigenous religion to formulate their own material for education. Hence, their children at schools are also allowed to be taught with their own beliefs. Previously, they were asked to join one of the religious classes. However, it's also in a lot of debate, since indigenous religion is taught in a completely different methods in the sense of modern pedagogic approach, such as the on some indigenous religions, it is only those who has the authority to secretly whisper the wisdoms of the indigenous beliefs are authorized to teach that beliefs, and those that has the authority at community level might not be the one who is able to be certified under the education kind of management, arrangement, which is very technical with a lot of, like administrative requirements as well as procedures. We are also seeing that women adherent to local beliefs are still, registering complaints on the access to employment, because several institutions are still not recognize the indivisibility of religion and beliefs, such as we have still received complaints on the difficulty to access work at the military institution and the police. And lastly is also on the places of worship and cemetery. The one that Commissioner Becca mentioned in Sunda Wiwitan is on cemetery, but also because in many society mind, the adherent of local beliefs are considered heretic. Some consider is Syriac, animist, etc. Hence, they are actually considering them against the constitution, against the state philosophy. So I think there is still a lot of layers of challenges need to be tackled by not only national human rights institution, but also at the societal level. A cultural movement needs to be done in order to change that set of mind. Thank you.
Thank you.
Thank you, Bu Andi. So now, everyone, we will try to conclude the sessions by 11 because it's Friday, and as part of the Nahdlatul Ulama movement, Pak Beka will need to go to the masjid. Okay, so I would like to invite comments and questions from the students. Perhaps from other country that has somewhat different experience from Indonesia. Can be Sharmila or is Sharmila?
Yeah. My question could be a little bit different from today's context, but in one of the presentation, maybe Rita's, I found out that the Indonesia defines children from their appearance in womb to 18 years old. And then I did a quick research on the abortion profile in Indonesia, because I have been doing my master's thesis in safe abortion in Nepal. We have, in Nepal, we have legalized safe abortion since 2002. It's almost 18 or 19 years, and women are still struggling to get safe service. And it has been one of the leading cause for maternal mortality rate here. So I want to know about the condition that you have in Indonesia. Also, how the Commission on the Women's Right is promoting safe abortion, And if there are any challenges, I would love to know. Yeah, thank you.
Yeah, thank you, Sharmila. There would be that would cover many issues, including perhaps cultural and law enforcement, and even some health issue that can be addressed. So yeah, but I would like to invite other comments or questions from students first before giving back the time to our resource persons today. Shafira, do you want to ask something?
I would like to ask a question to Bu Rita. With regards to the protection of child's rights in KPAI mechanism, specifically towards child victims. Bu Rita mentioned that the process of delinquency is still in need of improvement, right? Especially towards the rehabilitation of child in conflict with the law. But how about the fulfillment with regards to the restitution and the rehabilitation of the child's victims? How can you ensure that the damage of delinquency is restored if the process of rehabilitation only focuses on integrating the rights of the child in conflict with the law, but not the child's victims, considering they are mainly the ones that is highly affected against the delinquency? Thank you. That's it.
Thank you, Shafira. So it's not only about the, let's say, enforcing the law, but also the aftermath of the case, handling the victim situations. Any other comment? Third comment will be great. Ice or Patch from Thailand's experience. Do you have any comments or questions?
Yes, I have question.
Yes, Patch, please.
Yeah.
Bapak Ibu, ini Naris. How do you your name? Naris. How do you pronounce?
Yes, Naris. Yeah, Naris.
Naris, but we call him Patch.
Patch, yeah. And I'm sorry for my poor connection, so I can't like open the camera. But I have a question regarding my master thesis as well about the food security. As I know that for the Indonesian, they have like one of the most population for a citizen in the world. I just want to know that how Indonesian government trying to protect and to promote the food security agenda to support the citizen to reach their food security status, especially for those who are the vulnerable group, like the poor people or the children as well. Thank you.
Yeah, food security from the human rights perspective is always interesting.
Yeah.
Thank you, Pat. Thank you for raising the questions. Now, Pak Beka on Bu Andi on Burita, we have 3 sets of comments and questions.
Maybe Bu Andi and Burita first.
Okay. Yeah, it relates to mostly to women and children, but also with food security. Mas Beka can also give some comments. Thank you. Bu Andi or Burita first?
Silakan, Mbak Rita. Ya, makasih Mbak Andi. Firstly, about the right to life, Indonesia has the health law. This mentioned in the health law that the abortion eligible for some reason, for example, the health situation, and then the victim of the rape. And there is a process here, like counseling, there's their own choice, up to 40 days. This is, Indonesia is unique because there is religious, what we call it, maybe Islamic organization that also influence the law sometimes. This is the situation, but this is actually what the health law legalize about the abortion because of the woman situation, and also the health situation, and also when they are the victim of the rape, there's also a process and up to 40 days. And some of the situation is the illegal abortion, which is especially female become the victim because the process of abortion is not proper, then impact to the health condition of the female. That's the situation. And the second one is I will answer the question about the victim. Actually, children as offender also a victim of the situation. Not only the truly victim because they commit crime is because of the parenting situation, the social and the society situation influenced by many factors. And what we found when children become a victim of, for example, sexual violence against children, girls, for example, it's also difficult to find that they are got legal aids from the free legal aids. We call it postbakum, for example, because the juvenile justice system law emphasize to assist the children as a victim, as a offender, rather than as a victim. This is also our finding. That's why we endorse the Ministry of Law and Human Rights that their legal aids also support the victim. When they come to the court process, they are not being assisted by the legal aids. It is very important in this situation. They only emphasize on the offenders because that's very rigid. In terms of the juvenile justice system law, this law has legalized in 2012 and implemented in 2014, but we still have some homework, the regulation under this juvenile justice system law. That's why it's become a big problem to holistic implementing juvenile justice system law. And in terms of the victim, yeah, that's the situation that the budget, the human resources, for example, we only have 18 social worker in the whole of Indonesia, and we also only have limited psychologists in the whole of the Indonesia that can help them rehabilitation. This is also a big problem to rehabilitate the children. And when the children become offender, we in KPAI also advocate that the children in LPKA, the child icon, I don't want to say child, yeah, LPKA, the right of the education, because sometimes also it's also difficult. Sometimes they need to go out from the LPKA to get the education. During the pandemic, for example, not all of the children in the LPKA can get the access of education, for example. And also the health security insurance, for example, not all of them have it, for example. This is also what we advocate, that the basic health services needs to be provided by the Ministry of Law and Human Rights, for example. Yeah, this is the situation that linkage from the family situation, because sometimes the parents as the parents who has children as a victim didn't want to continue the rehabilitation because of the stigmatization. They choose to move from the location to another city because to stop their stigmatization, for example. This is the situation actually. That's all, Pak Gafar.
Yeah, thank you, Burita. Bu Andi, your comment, please.
I would like to touch with the third question first on food security. I also have that question actually, how the government are going to be succeeded with its food security program when in the same time it has a contradictory policies regarding the usage of land that actually in the name of development are allowing a fast extracting natural resources as well as converting fertile lands to infrastructural sites. The policy for food security can be traced back in the New Order regime in 1970s. However, Indonesia has never changed its policy of gaining domestic revenue from a more manufacturing industrial and even using raw natural resources to boost its national domestic revenue. And in all of this situation, women has actually experienced a very significant impact regarding the loss of their sites for gathering food, for planting their sources of food from home. Even we're looking at the multiple burden due to the scarcity of water and also herbs needed on the traditional medicine that they are more familiar with in handling their situation of health. So I think that is actually a very important question, and I'm also looking forward to my colleagues' response to that. And secondly, I would like also to touch the issue of safe abortion. As mentioned by Commissioner Rita, under Indonesian health law, it is possible to have abortion if you have a health issue, the maternal health issue, as well as the rape victim. However, it is very rarely to have medical personnel who would like to conduct abortion for women victims of rape. Komnas Perempuan has been in a close discussion with Ministry of Health in order to ensure that this facility is accessible for victims of rape. During this time, we have actually observed cases where women victims of rape trying to conduct abortion are actually risking her lives or actually end up in jail because she will be criminalized by abortion. We do not also have the law that will criminalize those who are enforcing the abortion, namely, say, the rapist or the partners of the woman who, due to their sexual intercourse, then do not want to, to be responsible of the condition of the unwanted pregnancy. Komnas Perempuan is trying to have this provision under the Anti-Sexual Violence Bill. However, the discussion in the Parliament are still at delay in this 2021. I hope that gives you some clue on the situation on the ground. Thank you.
Mbak Andi, now it drives my interest with regard to some non-physical health issue of the abortion. If it is for the mental need of the pregnant mom to have abortion, is that allowed by the law?
No, according to health law, there is a need to a very clear risk of life to the mother that is allowed to have the abortion. The second provision is for the victims of rape. And on victims of rape, it is the mental health that being the consideration.
Okay. So because in some cases of unwanted pregnancy, it's the issue of the mental readiness of a mother, for example. No, so it's not part of the...
No, unfortunately not. Yeah.
Not yet.
Yeah.
We have cases where a mother of 6 then tried to have an abortion because she is having the 7th pregnancy. And this actually, her case then is being exposed, and then she is actually now is sued before the court.
but not the husband. For whatever reason, the husband did not actually, okay, so let me just expand this discussion. So the husband did not actually agree for the wives to have contraception. In the original idea of anti-sexual bill in Komnas Perempuan, we try to also promote a provision on prohibiting enforced pregnancy, which is also like this kind of condition, because under the health law in Indonesia, for having a contraception, a wife needs to have the agreement from the husband. Hence, if the husband do not allow the wife to have the contraception, it means that it will risk the wives to unwanted pregnancy, and that may lead to an unsafe abortion. So we would like to prohibit this enforced pregnancy, not forced pregnancy as in the war crimes or crimes against humanity, but enforced pregnancy. However, it is considered too radical, too feminist. So we have, and the discussion of 2015 to 2019, this prohibition is dropped from the bill.
Okay, thank you. Thank you. That's a very interesting topic indeed. Mas Beka, time is yours. We have about 10 minutes to conclude the session.
Yes, thank you. About the question number 3 about food security. Actually, this afternoon, I will give a speech about those kind of issues, food security and the development paradigm and human rights in Airlangga University seminar. So I think it's kind of related with those kind of questions. Actually, more or less same with Andy's answer about food security. We cannot separate those kind of issue with a bigger perspective. I mean, bigger perspective. We have to look the economical paradigm in Indonesia, economic and development paradigm in Indonesia. That's, I think, the root of those kind of problem or issue related with the food security and then the right to food. Because in Komnas HAM, we identify there's a lot of violation of human rights that the cause is based on those kind of policy and strategy of the developmentalism. And then that's the first point. The second point, it's also, I think the condition is not changed very much since maybe Suharto's era's beginning in 1967 until now. There only understand that the one term of ideology, like investment, building, not try to protect the rights of the citizens or what kind of human rights that can be protected or fulfilled during the development eras. That's the second point. The third point is right now the data shows that the area of plantation, area of mining is always increased every year. That reducing and also change the life of maybe farmers and then peasant to fulfill the needs of foods or other needs, basic needs. That's why we have to address those kind of issues from the roots, and then the second is from the policies from the central government, rather than just addressing one cases, two cases, or three cases that maybe drag the public attention. And the last one is about infrastructure. I think the massive infrastructure development is also affecting peasant farmers or the grassroots levels of society to fulfill their basic needs daily. That's become a problem. That's why sometimes government always answering those kind of problem with instant policy, importing rice, importing other foods, and that, and so on and so forth, rather than try to implementing a sustainable development to fulfill basic needs of every citizen in Indonesia. That's my answer, Pak Gafar. Thank you.
Pak Gafar, I want to add a little bit about the food security.
Please do, yes.
And the impact of the children is the number of stunting in Indonesia is quite high, 27% up to now. This is the effect of the food security. And this is also the mentality, the way we think about the food security and impact in the family consumption of the food. Because the stunting itself is not only in the low economic society, but also 25% is in the middle class family. This is about also the perspective of how to consume food and the issue of food security for the whole of nation. That's all, Pak.
Yes, thank you. Just a little bit quick look at the other side of the food security in Indonesia for those who are not from Indonesia. The price of land in some cities are really high and keep going high, even if it's a agricultural area. So if, for example, if you are a farmer with less than a hectare of land, then you are in a great temptation to sell your land because it really costs you, it really gives you so much money. While when you are working as a farmer, it will give you limited income. So you will be rich if you lost your production tools as a farmer. So that's one of the problem in some cities. I guess it's not only about the right, but it's also about the general policy of the government. It's really different if we compare to the government policy in Thailand, for example. Patch and Ice can comment that later, but not today, because we are going to conclude the sessions. It's already 11. So once again, we have highlighted some issues that can be discussed later in our class, in our sessions when we are talking, for example, about the political actors, about the power and the interest in the human rights. So, but we really have to conclude this session today. It's been very fruitful discussion. I would like to thank all the resource persons, Bu Rita, Pak Beka, Bu Andi, and also Prof. Agus, and all those who gave comments to the sessions. Please join me giving applause to the resource persons. And I could see that Mbak Iyi is behind the steering wheel, so she's busy driving. So thank you, Mbak Iyi, for being with us from place to place. So I guess I will give this session back to you because you are you open this session and you are to close it. Thank you.
Oh.
Terima kasih, Bu Dita, Mas Beka, Mbak Adi. Terima kasih, Prof. Agus.
Thank you, Andi, Mbak Dita, Prof. Agus, Mbak Iyi.
Thank you very much for all speakers and participants. So I conclude the session. I hope that we can meet again and have more discussions about many issues on human rights, particularly in Indonesia and in Asia. So have a good luck, everyone. Have a good, healthy, and bye-bye. See you soon. Bye.
Okay, thank you.
Terima kasih.
Terima kasih.
Thank you. Bye.
Bye.
Yeah, success for the study and hopefully we'll meet again. Bye.
Bye.
Ketemu dengan Hanif segera.
Yes. We will meet again.
Siap.
Ayo Mas Beka, kita nikmati sroto.
Dan mendoa.
Mendoan.
Oke ya, aku pamitan.
Mendoan.
Terima kasih banyak.
Sama-sama.
Makasih.
Oke, semua pamit ya.
Thank you.